On the 22nd of January in 2022, Kennie Carter, who was aged 15, was stabbed in the chest with a long knife which pierced his heart and killed him. It happened on Thirlmere Avenue, part of a residential area in Stretford, Manchester. He was alone. The stabbing occurred because of a perceived grievance between Kennie Carter and his associates and with the four of you. This was yet another killing of a young person with a knife against the background of gang violence. Young males carrying knives in public in readiness to threaten and to kill others is becoming all too common in our cities, both here in Manchester and elsewhere in the country. The tragedy is that not only does it destroy the lives of the victims and their families, but also those who commit the offence, those who carry knives in the first place. All too often, as in this case, the killers are of school age. You were aged 14 when you murdered Kennie Carter. Latif Ferguson, you were aged 15, you were aged 14, and you were also aged 14 when you carried out this offence of manslaughter. What happened in Thirlmere Avenue followed two incidents the previous evening on the 21st of January of 2022 in the area of Victoria Park in Stretford. During the trial, there was evidence that individuals associated with Kennie Carter threatened some of your associates. A metal pole was produced as part of the threats. The precise detail is neither clear nor is it important. It led to the decision by the four of you for revenge. Together with 8 others, you travelled together across Manchester from Old Trafford to Stretford. Through CCTV evidence, it was possible to watch you as part of that group travel on the tram to the Stretford tram stop, then walk as a group to Moss Road and Thirlmere Avenue. The four of you, as part of that group, were looking for Kennie Carter and his associates in the Thirlmere Avenue area. You were intent on causing Kennie Carter harm, in your case, really serious harm. When you saw Kennie Carter walking along Moss Road and turn into Thirlmere Avenue, the four of you followed him. Along that road, you challenged Kennie Carter, and you stabbed him in the chest before all four of you ran off. Shortly afterwards, and was recorded on a CCTV camera, showing off and demonstrating his stabbing action to others, including to you, Ferguson. Thereafter, the four of you returned with the larger group to the Stretford tram stop and then travelled back to Old Trafford and to Hume. After he was stabbed in the chest, Kennie Carter managed to run a short distance before he collapsed. Members of the public, at the same time showing off what he'd done, tried to save Kennie Carter. His injury was not survivable, and he died in Thirlmere Avenue. This court and those observing have listened to the profound loss that has been caused to the family of Kennie Carter by his killing. His mother, Joan Dixon, has movingly described in her victim personal statement read by his aunt the grief of her family, which will never leave them. And during this trial, Mrs. Dixon and her family have had to listen to how Kennie Carter was murdered and to see and hear in the CCTV evidence the moments before he collapsed. In addition to this murder, I must also sentence you for the offence of Section 18, wounding with intent and possession of a machete, to which you pleaded guilty on the 23rd of October of last year. You were under investigation for this murder when you committed these further offences. I shall summarise the facts briefly because the sentence I shall impose on you will be served concurrently, that is, at the same time, as the sentence for murder. On the 10th of September last year, you were in Leeds when you chased down and attacked a 16-year-old boy on his way to his mosque. Together with another youth who was aged 14 whilst you were 16, you rode bikes and carried machetes. In a joint attack on the victim, he suffered deep lacerations to both of his arms, as well as fractures. He has suffered long-term effects as a result of what you did to him. Your co-defendant, being then aged 14, was sentenced to 30 months detention for those offences. Had you been sentenced at the same time, it's certain that your sentence would have been longer because you were older. It is argued on your behalf that the knife which you used to kill Kennie Carter was not your knife brought to the scene, but it was Kennie Carter's knife. You argue that I cannot be sure that it wasn't Kennie Carter's knife which you took from him to stab him in a disproportionate act of self-defence. I have listened to the evidence in this trial with care, and I am not persuaded that it was or might have been Kennie Carter's knife. On the contrary, I am sure that the knife used to stab Kennie Carter was your knife, which you took with you to use in revenge for what had happened the night before, on the 21st of January. I reached that conclusion for these reasons. A, apart from your evidence, which was rejected by the jury, there was no other evidence that Kennie Carter produced a knife at all. B, the CCTV evidence showed you carrying an object in the shape of a knife as you followed Kennie Carter. C, it's argued that the knife, Exhibit LJC16, recovered from a pocket inside a bag found underneath the body of Kennie Carter, and after he'd been bleeding freely from his chest wound, must have been his knife used against him by you. However, the scientific evidence within paragraphs 16 to 20 of the agreed facts is as consistent with the knife being inside the bag throughout and not used to stab Kennie Carter, as it is that it was used to stab him. The dimensions of that knife are by no means unique. Also, for it to have been the stabbing knife, rather than just inside the bag, becoming blood-stained and not produced, would have required Kennie Carter to remove the knife from his own chest or bend down to pick it up off the ground, and then place it carefully inside the pocket of his bag before he ran off and collapsed. The prosecution described those circumstances as absurd. I find them to be incredible. D, your previous convictions prove you to be a person who, both before and after this murder, carried knives in public. The year before, on the 28th of January 2021, you received a youth conditional caution for taking a large knife onto school premises 7 months after the murder. On the 26th of August 2022, you were convicted of violent disorder and possession of an offensive weapon, being a machete. 20 months after the murder, on the 10th of September 2023, you carried out a machete attack on a defenceless person in public, to which you pleaded guilty and to which I must additionally sentence you, as I have already said. In relation to the manslaughter, I accept that Ferguson did not know of or intend that a knife be used to stab Kennie Carter. However, I am sure that you three were present with intentionally to encourage him to cause harm, just falling short of really serious harm. After the incident the night before, when weapons were used to threaten serious harm to your associates, each of you travelled some distance across Manchester with and others to find and chase down your victim. Although you did not use unlawful force yourselves, you three were there intentionally to encourage to use force to cause harm just short of really serious harm. I do not accept that your journey together to Thirlmere Avenue that night was only to cause some lesser harm. I shall treat each of you as having played an equal role in the manslaughter. I have taken into account the youth guideline when deciding on the appropriate sentence for you. Each of you was 14 when you committed these very serious offences and are still aged just 16. Your age is just one factor, because I consider also your welfare as a young person in custody and your emotional and development age. I have been assisted by pre-sentence reports for each of you. For you, Ferguson, whilst the youth guideline applies to those under the age of 18, which is now your age, That guideline has relevance in your case because at the time you committed this offence of manslaughter, you were still aged 15. I turn now to the sentencing framework, first for murder and second for manslaughter. For you, at the age of 16, the sentence of murder must be detention at His Majesty's pleasure. The minimum term that you must serve before you might be released at the discretion of the parole board is set by paragraph 5A of Schedule 21 of the Sentencing Act 2020 at 13 years. That term requires adjusting to reflect both the aggravating and mitigating factors. After recognising that it already takes into account that you were 14 and that paragraph 4, subparagraph 1 of Schedule 21 applies to you, namely, you took a knife to the scene which you used in the murder. The factors which substantially aggravate the seriousness of this murder are firstly, that you acted with others as a group intending to harm the deceased. Secondly, that this offence was committed in a residential area where members of the public witnessed the shock of its aftermath. Thirdly, that this killing was against a background of gang violence and was in revenge for what had happened on the 21st of January, the night before the murder. Fourthly, that you have a previous knife offence and you must also be sentenced concurrently for the offences of Section 18, wounding with intent, and possession of an offensive weapon. The factors in mitigation for you are first that there's been a significant delay between the offence and your trial, a period of over 2 years, and you're now aged 16. Second, that whilst you had a youth caution at the time for this offence, you had no previous offending. And third, I have read letters from your grandmother and others who know you. I've also read in your case your pre-sentence report by Michelle Gregson, dated the 24th of July of this year, as well as an earlier report dated the 20th of November of last year, which was prepared for the Leeds Crown Court offences. In the latest report, you maintain that you acted in self-defence when you murdered Kennie Carter. That has been rejected by the jury. Also, you say that you were only 14 and that if you could, you would apologise to Kennie's mother. You've experienced significant trauma in your earlier childhood, with delayed emotional development, summarised in paragraph 6.1 of the report. You have witnessed domestic abuse in the home. You've been the subject of a child protection plan, and you've been in care. You have also absconded from care and been a missing child when social services were unable to find you. In August 2022, after this murder, you were referred to the National Referral Mechanism, who accepted that there were reasonable grounds for believing that you were a victim of criminal exploitation. No finding appears to have been made. Part of what may have caused you to commit this offence may be your need to appear strong and loyal to your associates who had been disrespected. The author of the report suggests that you will need therapeutic interventions to allow you to learn coping strategies. I turn to you, Ferguson. You're now aged 18. I'm satisfied that this offence of manslaughter falls within culpability B of the guideline for those aged 18 and older, because your unlawful act in participating in this attack was with the intention of causing harm, just falling short of really serious harm. As I've already said, I will consider the youth guideline because you have only recently turned 18 and you were 16 when you committed this offence. Both now being age 16, I must consider the manslaughter guideline together with the youth guideline. I'm satisfied that your culpability is the same as for Ferguson, being in culpability B. The factors which aggravate the seriousness of this manslaughter offence for each of you, Ferguson, are firstly, that you each acted with others as a group intending to harm Kennie Carter. Secondly, that this offence was committed in a residential area where members of the public witnessed its immediate aftermath. Thirdly, it was against the background of gang violence and in revenge for what had happened on the 21st of January. Fourthly, it cannot be ignored that the deceased's death was caused by a knife, although none of you knew that one would be used by. Those factors which mitigate for you, Ferguson, are firstly that you were aged 15, being born on the 14th of April 2006. Secondly, whilst you have a subsequent conviction for knife possession, I do not consider that it significantly affects your sentence, given my finding that you did not know about knife. Thirdly, you were not aware that you had a knife. Fourthly, that there has been a significant delay between the offence and your trial, a period of over 2 years. Fifthly, I have read a letter written by your mother, together with others, from those who know you, as well as a letter you have written to me. Further, within your pre-sentence report by Hannah Hancock, dated the 19th of July of this year, she reports that you are quite immature for your age and have considerable communication difficulties and with consequential thinking. She also reports some early life trauma within your family home and the likely effect it will have had on your emotional development. However, it appears that you have shown signs of greater maturity whilst you've been on remand. For you, in mitigation, firstly, you were aged 14, being born on the 26th of December 2007. Secondly, you have no previous convictions. Thirdly, you were not aware that you had a knife. Fourthly, there has been a significant delay between the offence and your trial, a period of over 2 years. During part of which you have spent time in local authority care, which will not count towards your time served. Fifthly, you have no previous convictions. Sixthly, I have read letters about you from the senior youth project lead of the Groundwork organisation. Further, your pre-sentence report by Hannah Hancock, dated the 19th of July this year, describes you as having performed well in the institutions where you've been placed before trial. You have not reoffended and have served a lengthy period in local authority care away from your family, which will not count towards your time served. Also, there are reasonable grounds for believing that you have been exploited for criminal purposes by others who are older than you, and that you have a girlfriend who is in the early stages of pregnancy with your child. For you, in mitigation, firstly, you were also aged 14, being born on the 15th of January 2008. Secondly, whilst you have some youth cautions, they do not significantly affect your sentence. You were not aware that you had a knife. Thirdly, there has been a significant delay between the offence and your trial, a period of over 2 years, during part of which you have also spent time in local authority care, and which will not count toward your time served. Fourthly, I have read the character references from your family and those who know you, and the educational assessment report dated the 4th of July of this year, which describes the progress you have made. Further, your pre-sentence report by Claire Stabler, dated the 19th of July of this year, describes the difficulties that there have been for you during your childhood, that you have considerable communication difficulties for which you required some assistance in the trial. Also, that you are immature in your consequential thinking and present as an immature young person. Whilst the issue of dangerousness has been considered in each of the reports on Ferguson, given their conviction for manslaughter, I decline to find them dangerous. Their young ages and the circumstances of this offence do not merit such a finding. Stand up. As I've already explained, the starting point for your minimum term is detention for 13 years. That must be increased to reflect the aggravating factors of seriousness before adjusting downwards for your mitigation. The minimum term you must serve before allowing for your time served on remand is 17 years. You have served 305 days on remand. Accordingly, for the offence of murder, I sentence you to detention at His Majesty's pleasure with a minimum term of 16 years and 60 days. For the Section 18 wounding with intent offence, I impose a concurrent sentence of detention under Section 250 of the 2020 Act of 36 months, with no separate penalty for the offence of possession of an offensive weapon. It will be for the parole board to decide the date of your release from custody once you have served your minimum term. You may sit down. Ferguson, would you all stand up, please? In respect of each of you, I must impose a period of detention. For you, Ferguson, it will be detention in a young offender institution. For you, it will be under Section 250 of the Sentencing Act 2020. I have explained why this offence of manslaughter must fall within Category B of the manslaughter guideline, which for an adult provides a starting point for sentence of 12 years. The factors which increase seriousness and which respectively mitigate for each of you, before taking into account your age, balance out in my judgment. I must then substantially reduce your sentences further for your age and maturity at the time of this offence. Ferguson, you are aged 15. I impose 5 years detention in a young offender institution on you, less the 269 days served on remand in detention, being 4 years and 96 days. You are both aged 14. I impose 4 years detention under Section 250 of the 2020 Act on each of you, less your time served on remand in detention and under curfew. For you, you have served 172 days, resulting in detention for 3 years and 193 days. You have served 154 days, resulting in detention for 3 years and 211 days. Ferguson, you must serve 2/3 of that term in detention and will be released thereafter on licence, the breach of which may lead to you being recalled. Because you are under 18, you must serve half of your detention before you will be released on licence, the breach of which may lead to your recall. Take them down, please.